event has begun. Let me begin by officially welcoming everybody, including speakers and participants, and of course my colleagues, to this curated webinar on governing AI across Africa. When we hosted the African Cyber Law Conference in Johannesburg in March, it became apparent that African nations are dealing with the same struggles around governing AI across Africa, but most importantly, within the legal profession. And it is for this reason that we decided to extend the discussion that was on plenary 2, moderated by Professor Michelle van Eck from Wits University. And we thought, let's have a post-conference policy dialogue where we at least try to map the approaches that we see emerging from African nations. We've got some representation from West, East, and Central Africa in the room, and we will continue to try and cover the rest of Africa, including North Africa, through future webinars. I'd like to formally recognize that the Law Society of African AI Professionals were closely with us at the African Cyber Law Conference to curate this high-level panel of speakers representing Tanzania, Nigeria, Rwanda, Ghana, and Kenya. And for this particular session, I've again invited my colleague, Professor Michelle van Eck, who is an expert in this particular field, to moderate this discussion and really just guide us through the main key points that we would like to extract and find out from this esteemed panel of speakers. So Professor Michelle van Eck is an admitted attorney of the High Court of South Africa. Her qualifications include a BCom Law, LLB, LLM, LLD, and I think this is a BCom Theology. Prof, you'll correct me if I'm wrong. as well as a postgraduate diploma in interpretation and drafting of contracts and a diploma in corporate law. She has over a decade of practical experience, having practiced as a lawyer, as well as a legal advisor in the travel industry, logistics, and supply chain industries, with a distinct focus on practical, contractual, commercial, and corporate-related matters. In 2019, she joined academia, and during her tenure at the University of Johannesburg, she served as the head of Department of Private Law in the Faculty of Law, and she also taught several undergraduate and postgraduate modules. She was also the recipient of the UJ's Vice Chancellor's Most Promising Young Teacher Award, as well as the UJ's Vice Chancellor's Teaching Excellence Award. She is currently an associate professor at the School of Law here at the University of Witwatersrand. Her research interests span an array of different fields, including contract law, the relationship between law and language, substantive contract theory, and also with interests on emerging or fringe technologies such as AI and smart contracts, legal practice, and of course, legal ethics. Professor Michelle van Eck, would you please take over this webinar? Thank you.
Thank you very much, Nomalanga, and thank you for the very generous introduction. I'm not quite sure who you were speaking about, but I appreciate that and I'm humbled by that. Thank you. So a very warm welcome to everyone on this webinar. And I just want to start off with saying that we've been dealing with quite a lot of issues in the legal profession in the last couple of years. And you know, with the arrival of AI as we understand it now, it's kind of created a particular type of anxiety. And this is not, it wasn't perhaps initially an anxiety of the unknown, but I think what we can say now is that it's rather an anxiety of the unregulated. And practitioners, including sometimes the judiciary, are already using these types of tools, and law firms are deploying them. And we don't really have much legislative and regulatory frameworks that tells us as lawyers what is permissible. and what is required to disclose, what amounts to competence or negligence when we're dealing with an AI-assisted matter. And those frameworks are in most jurisdictions still being developed. So there's obviously a gap that we're seeing between practice and governance, which is really a lived experience for many practitioners. And it's this gap that we're really hoping that we can start talking about today and continue that conversation. Now, what makes this session particularly unique is that we addressing these questions from the inside. And Nomalanga has mentioned, we've got contributors on our panel today that's working within their own jurisdictions from Nigeria, Ghana, Kenya, Tanzania, and Rwanda. And they're all navigating and advising and researching on how to regulate or how the regulations are working within their specific legal system. So not observing it from a distance, but hands-on. And I think it's important to recognize that the African continent is not a footnote in this conversation. Rather, the African continent is where this conversation is happening at the moment. So the intention of this webinar is to really unpack three major questions. What are we doing currently? What's been produced within these jurisdictions? And what do these documents that have already been produced mean for the lawyers on the ground? What does the legislation and regulation do at the moment? And what should we be doing in our legal institutions, our law schools, our bar associations, our professional regulators, and so on? So to help us navigate these issues, we have, and I'm quite excited about this, quite an impressive panel. We've got Ali Smart from Nigeria, Desmond Israel from Ghana, Renee Tikolo from Kenya, Rachel Machecha from Tanzania, Patrick Okello from Rwanda. And this panel, I hope, will give us some insights from different jurisdictions on this issue. Now, how are we going to approach this? I've asked each of our panelists to speak for 10 minutes just on these issues. And once we have gone through those presentations, we will then move into a bit of a dialogue followed by a Q&A session. So we're going to start with Desmond Israel. Desmond, I just want to perhaps introduce each of our panelists, and then what I'll do from there is if you're about 3 or 4 minutes from your 10-minute allocation, I'll just stick up my hand to indicate that before we move on to our next panelist. So just as an introduction to Desmond, who is going to talk about the position in Ghana, Desmond is the head of the Department of Public Law and Governance at Gimpa Law School in Ghana, a partner leading the cyber law and technology practice at Agnos Legal, and a former research fellow at the Center for AI and Digital Policy in Washington, D.C. He brings 2 decades of experience in cybersecurity, data privacy, AI governance, and also has advised governments and regulators and private institutions on digital governance, cybersecurity, AI regulation, data protection, and institutional resilience. And quite an impressive bio. I haven't done complete justice to you, Desmond, because I had to shorten your bio, but perhaps you can just, I'm going to hand over to you, and I'd love to hear what your views are from a perspective of Ghana. Over to you.
Thank you, Michelle. Thank you very much. And good morning to fellow panelists and, of course, the guest on the event. So I think to start with, it's okay to say that Ghana is not starting from a ground zero, not at all. But as far back as 2008, we already have what I would consider to be baseline digital laws. And as somebody who is not a fan of churning out laws every now and then, I can confidently say that between our Electronic Transactions Act to our data privacy laws and our Cybersecurity Act, we sort of have a regime that existed towards what I would call digital readiness, right? For example, under Electronic Transactions Act, we had already defined things that capture some of the activities of AI, right? Because we were clear in our minds what an electronic transaction is, what is an electronic agent, what is an automated process, right? And all these sort of definitions under our law tends to stretch to capture some of these activities. In fact, I took the pain to write a paper in the AI regulation and journal, AI law and journal, AI law and regulation journal, discussing how our Electronic Transactions Act is so futuristic in this sense that it's able to even bring into the conversations we are having about AI today by way of positioning it as electronic agents under the meaning of our laws. So today, what we are looking at more is trying to move away from, if you like, a policy imagination, or if you say, we are not within that policy imagination space anymore because we've done a lot of work on the ground. Yes, I do have some sort of concerns about some of the documents that we've churned out already. But to be very frank, we are at a point where we should be discussing if you like, the operational translation of what we have in those documents, and more specifically, if we are getting it into professional duties of lawyers. The document cycle that we've dealt with so far in terms of the policy roadmap, we've looked at the AI strategy for 2023. We currently, through a presidential launch, and had our 2025 to 2035 policy document. So our policy cycle has been within these two documents. We also recently did deal with the AI readiness assessment, which was launched in 2025. It's a UNESCO project. And then now we went into stakeholder validation from different sectors of our economy. And of course, like I mentioned earlier, on a presidential launch. That just happened on the 24th of April, if my dates are good. So the focus has now been just move away from that digitalization conversation to want to discuss AI governance. And so for me, these policy documents are not enough, but they are key signpost materials that would allow us to now move in to have those areas of conversation. Our policy discussion or strategy discussion has hovered around education, youth employment, I think, youth employment, yes, not development, youth employment, digital infrastructure, as trying to sort of like invest in compute power, and and that's another area that I have gone at length with discussing, knowing very well what our economic situation is, vis-a-vis trying to present these, if you like, very fancy expectations of implementing digital infrastructure. I would have expected a little bit more on the realities connected to our very existence as a country. Strategy also looks at data governance. So in the 2023 document, we didn't really discuss that. But in the 2025 document, there seems to be a shift in trying to ascertain how we're going to deal with data governance in terms of collection of information, cleaning it up, using it for training, language efficiency, and all these things. Now, these are all relevant even to the legal profession. And I think because I'm giving a baseline of what we have done so far, it's worth mentioning it. There is a component in there for applied research and also public sector AI use. So that pretty much gives us, if you like, a head start in terms of where we should look at and what we should start doing so we can move forward. Our ecosystem governance is both executive, legislative, and of course the judiciary. On the executive level, there are a number of existing agencies. So I can say, for instance, we have a Ministry for Digital Technology Innovations that has spearheaded the 2025 AI strategy itself. There is the National Information Technology Agency. We have a Data Protection Commission. These are all functional agencies, and that's why I find it relevant to mention them in my introductory presentation. Our Cybersecurity Authority is also poised in terms of the cybersecurity issues that comes with some of these platforms. Academia has been involved at GIMPA, where I had public law and governance. We actually have full set training for our LLB students when it comes to AI. Actually dealing with law and technology as a big picture. KNUST, which is another academia hub, where one of the biggest universities in Ghana as well, also has a responsible AI lab. We've had partners like GIZ, UNDP, UNESCO, and the rest. I'll wrap up around how do we see these connecting with the legal profession, and then I'll give the opportunity to other colleagues. So currently, well, this is my submission, but I think that the focus should not be us waiting to get an omnibus law. Why? Already the regulator for legal practice and studies, which is the General Legal Council, has a statutory footing. There is a complete law in addition to ethical guidelines that lawyers are supposed to comply with. Now, if you break down the AI governance structures and you want to try to address them, human in the loop, non-discrimination, and all those things, you pretty much find them aligned with existing legal practice requirements already, which is you're required to have the competency. So whether you're dealing with land litigation or AI-infused litigation, whether from a technology, law in technology perspective, or you are using AI to do your work, which is technology in law perspective, competency is still required of you. Diligence is still required of you. The errors of technology will not be shielded because there is no moral agency. That's not how it works in Ghana. You would actually take the liability for it action or courtroom action. Client communication is clearly defined. We are required to have confidentiality. The conduct in court is also defined. So you pretty much can present hallucinated cases in court, whether it's AI generated or it was the figment of imagination of your paralegal. You're still going to have responsibilities coming with it. The requirement of fairness, provision in law firms, and responsibility for non-lawyers is all already defined in law. And so for me, I see where once we are enforcing the strong legal professional accountability regime we have already, we may want to just align. So for instance, what would it mean to lawyers, for instance? Verify the research, protected client data, informed consent, no hallucination of authorities. For the courts, compromise on trial, nope. Human in the loop. Evidential integrity. The Evidence Act is pretty much clear about some of these things. Judicial independence. You can't, if you like, subcontract the judge's role to technology and not have any sort of supervision over there. In our regime, we require reasoned decision making by the courts. So courts must give reasons for the decisions that they proffer. And these decisions, if they are going to be AI generated, would need to be clarified. You need to be clear what the human agency or the moral agency of that decision is. So that pretty much already guides you. Any sort of technology you are going to use at all, including AI, what your responsibility is to the legal profession. And of course, for law firms, definitely about governance, how we procure, how we manage data of our clients, and of course, for the supervision of the people that we work with. In terms of response to the ecosystem or for legal education purposes, which is where I round up, I think that law schools should teach AI. They should. And I have a theory about how academia is currently grading AI work. We are doing output grading, which for me does not actually help the student or the trainee learn and exercise industry using technology, right? And this is very simple. That is because once the work is generated and you put it in an AI engine and it's 50% AI, you're done. The student has not put in industry. But I think that you should look at what research these students are doing. what sort of content they have in their LLM notebook, for instance, how they are assessing the reason they put behind their prompts. These are where we need to start from if we want to adapt AI, train it, and get it used responsibly. Of course, in addition to all other requirements for competency in legal methods, ethics, evidence, advocacy, data protection, and the likes. So yes, we do have a strong national vision as we speak now, but it is not a bankable implementation plan for the legal profession yet. And I think that the legal profession could also look at how it aligns some of these conversations and on some of these policies in these documents to begin to guide how practice goes forward. We already have a regime. Like I said, there's a very strong regulatory regime, and we can only leverage and build on that. So I just come back to you, Prof. That will be my introduction.
Desmond, before you put your camera off and before I move on to the next speaker, I find it very fascinating, the position within Ghana. You know, it sounds to me like it is expanding or conceptually adapting existing principles. I see that a lot of the Western countries, I'm looking at America, for example, the UK and so on, they've taken a little bit of a different approach, and they almost started with regulating ethical codes of conduct within the legal profession. I just want to conceptually hear from you. Do you think that is perhaps a good approach, or do you think it's sufficient for us just to expand the existing principles? Because you kind of made a very good argument that nothing changes, right, in terms of our duties. But I just want to briefly get your thoughts on that before we move on to our next panelist.
Yeah, right. Thank you, Prof. So I think the expansion of existing principles, it's the way to go, and it's informed by both my work in practice purely as a lawyer, doing technology, and also recently working in policy space. Now, the thing about policy is that the house of policy is politics, right? So for the greater part, you are looking at more of executive decisions on how things are supposed to be done. You don't need to reinvent the wheel, if I'm allowed to say that, because the harms that comes out of technology, and the truth of the matter is nobody really regulates technology. We regulate the behavior and the outcomes that comes from technology. So if there are existing structures through which we are having all these controls in place, save for where these controls are not properly implemented, and therefore the system itself is weak. But not when lawyers appear before disciplinary hearings, not when clients have been empowered to even sue lawyers for infractions here and there. The same infractions can be exacerbated by AI. So in my own assessment, we need to strengthen the current regime and then plug in where, if there are any new controls that we need to add, we'll do that. But to scrap a system and try to rebuild some sort of ethical module around the use of technology, in this case, artificial intelligence, is for me a course that really is just us trying to look for something that already existed. And I think that it's a good point to sum up. So I would skew towards expand the existing principles rather than trying to scrap it and beginning all over again. You would just end up with so many overlaps that existed in the prior structure.
Thank you, Desmond. Sorry, I had a moment there with my microphone. Thank you so much. I'm certainly going to circle back to this a bit later, but perhaps I can just summarize, which I found quite interesting. You were saying not only expanding the existing principles, there's no need to reinvent the wheel. So, you know, the argument, it seems to be, is that these professional duties already exist and we just need to expand that and adapt it to the existing space. I really found it interesting where you were saying we're regulating behavior and not technology necessarily, which is, I think, foundational to what we actually do with law. So thank you for that, Desmond. I'd like to perhaps turn to our next speaker, Renee Tekolo from Kenya. And I kind of want to see how Desmond's position from Ghana kind of works within the space of Kenya. And specifically, both Renee, your position, and later also with Rachel in Tanzania, because I think there's a very different approach potentially. It's really my honor as well just to introduce Renee. She is an advocate of the High Court of Kenya and a legal researcher whose work really examines how the law adapts to technological change. And she is a researcher with the Africa Privacy Roundup project at Privacy Hub Africa, and a fellow of the Africa Privacy Book Club. She is a member of the Law Society of African AI Professionals and the Association of Privacy Lawyers in Africa. And her work focuses on the broader commitment to strengthening African perspectives in technology governance and the shaping of legal and policy responses to AI and digital transformation. And again, Renee, I'm going to ask your forgiveness here, because I do think that I am not doing justice to your CV and your credentials, but this is just a slight highlight for our viewers and our audience. Renee, I'd like you to, it seems to me like Kenya has done quite a bit from a regulatory perspective, and perhaps you can just take us through that. Please go ahead, and looking forward to seeing hearing your perspectives.
All right, thank you, Prof. And thank you everyone for being here. Good morning, good afternoon from wherever you're at. As you've heard, my name is Renee, and I'd just like to briefly take you through the AI governance landscape, particularly in Kenya today. It's very layered, but I'll focus on two main documents, mainly the National AI Strategy for 2025 to 2030 and the AI Bill, which was introduced in March, actually, this year. So briefly, I'll start with the strategy, the national strategy, which was published last year. And it's non-binding, it's a policy document. And its focus is mainly to provide the vision of AI, particularly for Kenya. And the approach that it takes is a three-layered approach. Innovation first, development first, and rights anchored approach. So what does that mean? That means that basically in Kenya, our focus is we want to become the leading AI development we want to lead AI development in Africa and create local AI models, data sets. And basically, the document actually says we want to be the leading hub of AI innovation in Africa, but do it within a way that meets the local context and unique needs of Kenya and of Kenyans on the ground. We also want to use AI for development, basically to solve problems, real life problems that we have in Kenya within various sectors, particularly health, finance, education, and public services. However, it also mentions that in as much as we are pushing forward innovation and we are pushing forward development, we want to have a rights-anchored approach. So basically, we focus on ethics, inclusion, and human rights are taken into account, even as we create and deploy AI. The strategy also notes that as we do this, the governance of AI has to have a balanced approach. What that means basically is we foster innovation and we also have the necessary safeguards. So it's not one is prioritized over the other, but it's a balanced approach. We look at both and we prioritize both. And the strategy highlights that we do this by first understanding the current AI ecosystem in Kenya, and then we will slowly begin to develop, be it regulations, be it institutions, to help push both this innovation forward, as well as the governance frameworks forward. But as I even say this, like I mentioned, we currently have an AI bill, which was introduced last month. So it's a good thing in the sense that it is the first binding AI specific legislation in Africa. But the AI bill was the way approach that it takes a more governance regulation heavy approach. Like I mentioned, the strategy is mainly pushing innovation. We want to, adapt in regards to technology. We want to recognize the fact that within Kenya, the main people who innovate with AI are the local, startups, SMEs, and we want to push them forward and incentivize them. But the bill does the opposite of that. It regulates the creation, deployment, and even the development of AI heavily. And you can also see in certain sections, for example, section 25, classifies AI based on risks, and that is a direct copy from the EU AI Act, and which is also very strange from my perspective, considering we haven't taken time to fully understand the AI ecosystem in Kenya. It also establishes new institutions, such as the AI Commissioner. It gives the Cabinet Secretary, the current Cabinet Secretary of the Ministry of ICT, very broad powers to create regulation, which contradicts again the strategy which says that we will first use what we currently have in Kenya, the current laws, the current institutions that we have in Kenya. So the AI bill is a good bill, but it has many gaps, has many loopholes, has a lot of heavy obligations on the local innovators. So many people, there's back and forth within Kenya with regards to this AI bill. People are asking, is it really necessary at this point in time? Should we have taken time to understand the local context? But that's just a brief overview of everything. Forgive me if I'm not given a very detailed one. I have more, but due to time, I'll just move on. So what does this mean particularly for lawyers, and what is the professional responsibility that is imposed on lawyers based off of these two documents, or based off of the current architecture that we have in Kenya? So none of the documents, none of the published documents explicitly mention lawyers, but I believe they do target lawyers in one way or another, particularly because lawyers, we already operate under very strong professional obligations. As my previous panelist has said, competence, confidentiality, integrity, transparency. So these documents, or this policy and soon to be law, raise the standard of those duties, particularly in this now AI governed society that we live in. So I would say what changes, particularly for lawyers, the biggest shift I have noticed is competence, particularly AI literacy. Lawyers need to understand how AI tool works, the risks, the limitations, and when it's appropriate to use it or when it's prohibited to use it. Also for lawyers who are advising actors within this landscape, be it providers, deployers, developers, they also need to be able to have that competency to advise such actors when it comes to their work and when it comes to the deployment of the AI systems that they deploy. Another thing is confidentiality and data protection have been elevated quite a bit. For lawyers, we have a very strict and stringent duty of confidentiality. We can't just input anything and everything within AI tools. And many of the AI tools that we use are public AI tools like ChatGPT, Claude, Gemini. So we still have that duty on us that we have to be very careful with how we use these tools as we generate our documents, as we draft our pleadings. And in connection to even pleadings and drafting, that connects our duty to court. I think one of my panelists already mentioned it. You can bring hallucinated citations within your pleadings to court. And actually in Kenya, the use of drafted AI pleadings has been banned by the court. Last month, the High Court here in Nairobi stated that no lawyer, no law firm should submit pleadings that have been drafted using AI until the law or legislation has been created to regulate that particular use of AI. So in Kenya, we do have that law that has come into place, so which also limits lawyers and how we use AI here in Kenya. I would also say supervision. It imposes a duty of supervision on us as lawyers, because as lawyers, you have your junior staff, a bit in a law firm or wherever you work. So if your staff is also using AI, we are responsible for how they use AI as well. You can give a junior staff to draft a contract, and they use an AI tool and it has hallucinations. If you're not aware of that and you send that to a client, that can bring about a number of issues. So The bottom line I will say is there are no new duties that have been created, but they have been elevated. And I think it's important that we take note of that, and even we begin to recognize and realize how we can now maybe put that into I would say maybe like a codified document to guide lawyers, because like you said, Prof, there's a lot of uncertainty around it. Yeah. Thank you. Back to you, Prof.
Thank you, Renee. Thank you so much. And before you run, sorry, it's all very, very interesting because you did mention, and I've got many questions for you, but we will address it perhaps a little bit later. But what excited me a lot was your mentioning of the High Court decision. I think it was in April, right? What was quite interesting for me on that particular case, and the way I read it was that the person that used the litigant that was using the AI, there was no hallucinated information there. It was a properly drafted document. It was factually correct, and the court seemed to take exception to that. I'm not going to go into the correctness of the interpretation of the civil procedure, but what I wanted to get your thoughts on is the court seems, and I'd love your views, because it seems to me that the court kind of moved away from the intention of Kenya. If you look at the national AI strategy, the AI bill, this intention that you've described to be the first in Africa, to be the leader in AI, and yet to have a judgment effectively removing the one thing that brings, let's say, a layperson to the same level of a practicing lawyer, almost a little bit penalizing. And I'd love to hear your views on that. How does this court case reconcile with the greater strategy in Kenya? What are your thoughts, Renee?
Thank you, Prof. I actually agree with you. It was a bit shocking to see the High Court release such a judgment. And they gave the reasoning, with all respect to the judge who gave the judgment, the reasoning for me was quite, like a better word, I'll say interesting, because they said that it created an imbalance, that the party who didn't use the AI tool was at a disadvantage. But just like you said, the party who actually used the AI tool was self-represented. He was a claimant. He was self-represented, meaning he didn't have a lawyer. He didn't have knowledge and access to all the legal tools that we did, and he simply used an AI tool. So it's a bit, for me, from my perspective, I see that it's a bit contradictory to what we are trying to build and even the goals that we have as Kenya, and leading and pushing innovation and the use of AI tools. The court did mention that it would be prudent to legislate on how we use AI tools as lawyers. But I personally believe it erred in the sense when it says that we should legislate and amend the civil procedure rules. But before AI came, we were using research databases, we were using research tools, we were using things like Grammarly to check and Grammarly and check our work, in terms of grammar and language. And all these are not legislated by the civil procedure rules. So then it's an interesting position that the court has put us in. And I would also like to see what the Law Society of Kenya will do. Will they take it up? Will they release codes of standard with regards to AI use and how lawyers should use AI? But I think, to answer your question, it puts us in a very awkward position as Kenya and even as lawyers. Yes.
Thank you, Renee. That's certainly a fascinating development, and things never go as planned, I think, in these situations. So I think we will also probably touch on this again at the end. So thank you very much for your insights. I'd like us to then perhaps move on to our next speaker and panelist, Rachel Macheche from Tanzania, which I think is going to potentially bring a very interesting perspective. Rachel, perhaps you can just put on your video, if possible, just to see that you are ready to speak.
Yes, my video is on. Can you see me?
Oh, there you are, Rachel. Wonderful. Excellent. So it's my honor to also introduce Rachel Mokgege, who is a data protection lawyer based in Dar es Salaam. She serves on the board of Tanzania Privacy Professional Association. She also sits on the board of directors and serves under the Research and Professional Development Committee, which oversees the planning and execution of different knowledge sharing forums and publishing of research papers. She also has worked on a large number of project management and implementation projects with really specific focus on policy and legislative analysis. She is a member of Tanzania's Women Lawyers Association, Law Society of the African AI Professionals, and Association of Privacy Lawyers in Africa. And I have to just add here, Rachel, I had to do a qualification to say just to name a few, because you're sitting on so many boards. It's very impressive. And she's also recognized as an expert on the by the OneTrust data guidance. So it's an absolute honor having you as part of the panel. And I'd love to just get your views, Rachel, from Tanzania, because I think it's in a stark contrast from my understanding from Kenya, and just the views on AI usage and so on. So if I can hand that over to you, just to get your views on Tanzania's position. Thank you.
Thank you so much for this opportunity. Please do let me know if my internet becomes unstable at any moment. Thank you so much, ladies and gentlemen. Good afternoon, good morning, good evening from wherever you're from. Thank you for having this time to listen to me. Yes, I will be giving you an overview of the AI governance landscape and developments here in the United Republic of Tanzania. More specifically, Tanzania does not yet have an official national AI framework or strategy. There is a draft version that was published last year in 2025. At the moment, I believe it is still going under review and multi-stakeholder consultation. And so when it comes to matters of AI governance, that specific document would be leading the nation. So we may see it come out officially this year. And then also it is very important to know and even to remind ourselves of what these terminologies mean, because you will hear words being thrown out: framework, policy, strategy, convention, legislation, and things like that. In my presentations, many times I always tell people to be very careful of what these terminologies mean and look at what your jurisdiction or what your area is prioritizing at the moment. With Tanzania, the document is a strategy. They call it the National AI Strategy. And so what does the strategy mean? Let us remind ourselves the strategy is basically a plan that you put to achieve something. If I say, for example, I want to be the president of South Africa in 10 years. What's my strategy? I'll do 1, 2, 3. And so what you'll see, even with the Tanzanian document, is that it says strategy on where Tanzania wants to be, what it wants to do with AI and what it wants to achieve. And what is it that it wants to achieve? Specifically on the rationale page, and I'll be happy to share a link here in case anybody would like to read it. It specifically says that our rationale for creating this document and this instrument is for economic improvement and economic transformation. And then you will see other specifications that talk about public service delivery, public administration, and things like that. Just to give you a picture of where Tanzania is and what it's prioritizing with matters of AI governance. Again, it is important to also know, for anyone who may not know, similar to Mr. Desmond, as he was starting also in his presentation, there was a project conducted by UNESCO on how ready Tanzania is to implement artificial intelligence. And so last year, again in 2025, an official report was put out on the AI readiness measures that Tanzania has. And after that, there were some stakeholder consultations. I was really happy to be a part of that. Ladies and gentlemen, with AI governance in the Tanzanian space, just after that overview of frameworks and laws and policies and things like that, I'm seeing some things and some efforts that had come up a little bit in the education sector. Nothing major specifically, but some smaller institutions already had started putting out master's programs, for instance. To my brothers and sisters from South Africa, you will be happy to know this. There's a Nelson Mandela University here in Tanzania. Some people may know about this. So there's a Nelson Mandela African Institution of Science and Technology. It's in northern Tanzania, and it is currently offering master's programs in data science and artificial intelligence. It's a 2-year program. I looked and did some research on it, on the national curriculum institutions and places like that. They did make some changes and adding more financial literacy courses and programs, technology here and there, more languages, but there was nothing maybe specific to AI. Maybe in those courses, there might be a topic that will be taught on AI, but there was nothing specifically catered to AI. With Tanzania also, there is a Data Protection Act that came out at the very end of 2022, and that also established a Data Protection Commission. So far, in terms of protecting people's data and looking at responsible AI use against things like bias, discrimination, and automated responses that can be harmful, the Personal Data Protection Act of Tanzania does give a right to all data subjects and to all individuals against automated decision making or against automated processing. But that's just about it. And so you do see that there is more we wait to see and hope to see in the Tanzanian space with regards to matters of AI governance. Interesting also, there hasn't been many or barely any judgments or case laws on artificial intelligence. I was doing some research about this, and you do see in some judgments a sentence here and there that says maybe not to use AI for this, this could be harmful, this and that, but nothing specifically a case that maybe someone filed in court against a deep fake or against some AI decision that was made that harmed them financially or things like that. So I await to see those. It will be very interesting. And then before I come to my conclusion and talk about the legal profession and how AI governance affects it, this is just also my personal opinion. I really wish and hope to see that the AI strategy in Tanzania will come out in Kiswahili as well. The parliaments are now in a system, and they had started some time ago where they first publish or put out laws in Kiswahili, subsidiary laws, bills, and all that. They put them in Kiswahili, and then they translate them into English. I just think it would be really interesting to see a whole AI strategy from beginning to end in Swahili. And I also think it will be a very beautiful thing to members of the Tanzanian community who do not speak English and who do not understand English, but they are being affected by AI in one way or another, and maybe even using AI. I mean, Meta AI is on our WhatsApp, and there are people almost everywhere using WhatsApp. You can imagine the local mama in the village who has a WhatsApp group for her business, and she uses WhatsApp, and there's Meta AI over there, and she may not know how it's done and how this and that works. I did try to play around with the Meta AI on WhatsApp, and I can confirm that it can answer you in Swahili. at least for our context. So I was a little bit happy about that it can understand Swahili. And so in the legal profession, ladies and gentlemen, as I wrap up, in the legal profession, we are going to see a greater need for, as I wrap up, we are going to see a greater need for lawyers to not just understand AI laws or frameworks or strategies, but to also understand what AI is, how it is made, how often it is used, how it develops. There is going to be a greater need for classrooms, law schools, departments of law to put out specific artificial intelligence courses and programs. And many cases are going to come up as well. So that will be a very interesting thing to see how cases are being handled on matters of AI. The judiciary in Tanzania, for anyone who may not know, is also implementing and using AI technology specifically for court transcriptions, analyzing evidence, and things like that. My time is up, but I will be discussing more things in detail as we continue with the panel segment. Thank you so much, everyone, for listening to me.
Thank you, Rachel. It's really fascinating for me in terms of where the position you've described in Tanzania. I must say it's interesting because you mentioned that there's little or no judgments within the space. I find that interesting because if we look at internationally, it's probably the use of hallucinated judgments and the disciplinary kind of cases that are coming out are flooding the the law reports at this point. We're looking at there's a resource I found where we're looking at thousands of cases internationally, and I wonder if we need to look at the model within Tanzania as to what are you doing right to do that. And I think it's coming down to comments you're making with regards to education, right? And how do we educate individuals? And my thought, just before you run, I want to just ask you, what do you think is the need? You mentioned that there's a need for lawyers to understand AI, to engage with that in a little bit more specificity, if I can use that word. But where would that education sit? If you can maybe just talk to us a little bit about what your views would be with creating a consolidated kind of education for our future lawyers and our current lawyers to be able to engage with this area of development. What are your thoughts, Rachel?
Thank you so much for that question. My thoughts, very, very quickly, my thoughts are that the need and the importance for lawyers, current lawyers, future lawyers, is with regards to understanding how artificial intelligence works, how they will be able to advise their clients when there's a need with regards to anything AI, how they can also practice better, draft things better, because you don't want to be in a place where you are using AI, you don't fully understand it, and so that means you fully trust it. Because with technology, people want technology to help make things faster, make things easier. And so they fully trust technology. And that is what we see with AI. So lawyers need to understand what AI is, what it is doing, its limits, and how it can help you, so that to avoid any challenges, any issues that may come up. I just think that a lot of lawyers, and I'm seeing in the Tanzanian space, yes, they do know AI frameworks, AI laws, AI developments, but if you ask them, what's the difference between a generative AI and a predictive AI? Or can you tell me the difference between agentic AI and generative AI? Those basics. I don't think a lot of them know. And so I think it's important for them to know that. And I will be sharing more other examples as we continue in the panel. Thank you so much.
Thank you, Rachel. And just on that mentioning of agentic and generative AI, I mean, the agentic AI development may very well put at risk some of these educational initiatives. And that requires, again, a robust framework, I would think, to be able to engage with that, and also a developing educational space. But I'd love to hear your thoughts on that as we progress to the discussion section. Thank you again. Wonderful insights from Tanzania, and we will certainly continue the conversation. So thank you for that. I'd like us to then perhaps move on to our colleague and panelist from Rwanda, Patrick Okello. And Patrick is, and if I can perhaps just see if Patrick is online, if you can perhaps just put on your video for a second, then I know that you are ready to present and talk to us about the position in Rwanda. Patrick, are you with us?
Yes, I am. Thank you, Michelle.
Wonderful, wonderful. Thank you, Patrick. All right. So Patrick is a consultant at Adili Rwanda, part of the Pan-African Adili Group. He serves as vice chair of the Cross-Border Practice and Regulation Committee and as a member of the Digital Protection and Privacy Law Committee of the East Africa Law Society. He has co-authored legal analysis of AI governance frameworks across 7 African jurisdictions for the Thomson Reuters Foundation. And although Patrick is, and this is very impressive, Patrick, I'm feeling a little bit intimidated, but you are knowledgeable of Rwandan, Ugandan, and Kenyan laws, and you've studied and worked in all of those jurisdictions. But what we would really appreciate from you is your Rwandan context to our discussion, and your cross-border practitioner view of the legal institutions in the East and Central Africas and what's happening there. That will really add a lot to the conversation. I believe you've got a presentation. If you would want to perhaps share that, Patrick, then I would invite you to do that. And while you're doing that, again, apologize to all of our panelists because your CVs and bios are much longer and much more impressive than I am giving you credit for. So we are truly privileged to have you here. Patrick, do you want to perhaps, I see you've opened that up, 100%. Let us wait for that, and then I will hand over to you, Patrick, for your views from the Rwandan position.
Thank you, Michelle. Good afternoon from Kigali. I hope my presentation is visible to each and everyone.
Isn't yet. We are seeing your desktop view, where the files are showing. So it's not showing at this point in time. So yeah, I will let you know as soon as it's showing, Patrick. It's there we go. Again, just showing the position, desktop view. Perhaps we can just see if we can't get that working. Otherwise, Patrick, you are also welcome to continue.
Sure.
And yes. All right, let me hand over to you, Patrick, and then I look forward to hearing your views.
Thank you, Michelle. Apologies for that. I prepared a very glossy presentation, but stuff happens. So I'll take us through the AI landscape in Rwanda. I've prepared a three-part presentation, Rwanda's current AI governance landscape, the interaction of AI policy framework with the legal profession in Rwanda, and finally, recommendations to legal sector players. Now, with Rwanda, just like other African countries, we were one of the first countries in the continent to adopt a national AI policy. However, we do not have a specific legislation governing AI at the moment. Nevertheless, there exists laws and soft laws that we still rely on to govern AI. This, of course, include the data protection law, which was gazetted in the year 2021, the intellectual property law of 2024, the ICT law, which has been around for over a decade, and of course the national AI policy, which of course came into effect on the 20th of April 2023. Now, the national AI policy recognizes the integral role of AI in the society and serves as a roadmap to enable Rwanda to harness the benefits of AI, while at the same time mitigating its risks. Although it is not legally binding, it interacts a lot with the laws that I've previously mentioned. It prioritizes transparency, accountability, fairness in AI deployment, and requires stakeholders to ensure explainability and responsible data governance. So in essence, it has a quasi-regulatory effect since it is used as a guide for government institutions, regulators, and even those in the private sectors, such as lawyers. Now, on the second bit of my presentation, the interaction of AI policy framework with the legal profession in Rwanda. As I previously mentioned, there is currently no regulation that governs AI. Same to the Bar Association, there is currently no regulation that explicitly regulates AI. However, we still rely on the internal regulations, which provide rights and obligations that are binding to lawyers. These, of course, include confidentiality, competence, and integrity, amongst others. So in essence, lawyers are expected to act with integrity and to protect client information as part of their fiduciary duties. So we've seen a lot of adaptation of AI in our legal work here. We mostly use AI in different areas, including legal research and e-discovery, where we use it for document automation. Most law firms do that. For legal analysis, for case management, and even for preparing information that I use to disseminate, any developments through different channels, could be websites that are, relevant to lawyers. Now, for lawyers, just like my colleagues have mentioned, the use of AI, of course, continues to introduce risks such as data leakage, hallucinated outputs, and algorithm bias. In several instances, we've noted AI tools producing incorrect legal citations and even hallucinated case laws. And this, of course, expose lawyers in almost all jurisdictions to malpractice suits. So despite all this, it has become, a very important and integral part of our practice. So, lawyers are in this day and age expected to take into consideration, the AI capabilities and limitations. On the third bit of my presentation, the recommendations. I will recommend that law societies, including the one such as the one I am a member of, should develop AI-specific ethical guidelines. They should also mandate AI training for legal professionals, and they should also amend their internal regulations, to reflect the times. Some of these regulations are many years back, and things change. There is technology, so they should adapt them with the various AI policies. The legal sector players should also consider themselves stakeholders in developing AI ecosystem, and should, in essence, also endeavor to play integral roles, especially in policy making processes, and to collaborate with other stakeholders, other players towards realizing Pan-African AI legal standards. Now, in my conclusion, I'd like to suggest that, as with other countries, the use of AI and adoption of it is not it's not optional to lawyers. It is already here with us. It is a question of the question is not whether lawyers will use AI, because in real sense we are doing that. So the right approach should be, it should be used responsibly, ethically, and in compliance with the evolving governance frameworks. Thank you. I hope adhere to the time frame.
Patrick, you are spot on time. You were actually you still had a few minutes. So I'm going to, as moderator, abuse those extra few minutes and perhaps ask a few questions if you would indulge me. I find it quite interesting that you mentioned that there has been a few cases where, and if I may be as bold to say, lawyers being a little bit naughty with the use of AI, and the courts having commented on that. Just as a starting point, Patrick, has the Bar Association or Law Society within Rwanda responded to that at all? You mentioned that there's nothing yet, but is there anything in development from the Bar Association in that space?
Thank you, Michelle. Actually, the cases I alluded to are from other jurisdictions.
Okay.
We haven't been privileged to have such a case here, but as it stands now, I know the Bar Association, in collaboration with the East African Law Society, is doing a lot to educate lawyers on responsible use of AI.
Oh, wonderful, wonderful. So it looks to me like we need to learn something from Rwanda, and also from what Rachel was saying from Tanzania, because in South Africa we've had a few of these incidences. But perhaps I could just then ask you, Patrick, you seem to be advocating that there is a need to update our regulations and our guidelines to align with current policies and AI. That seems somewhat starkly contrasted to what Desmond was saying a little bit earlier, in terms of adapting existing frameworks. Perhaps you could just give your view as to why the existing frameworks may not be fit for purpose, if I am summarizing your view accurately. I'd love to have your views and thoughts on that.
Thank you, Michelle. I'll give an example of the Bar Association that I belong to. The internal regulations and the law governing the bar was gazetted in the year 2013. That definitely is before the use of AI took off. So as we stand now, and as a matter of being honest, most lawyers employ AI to either fasten the delivery, but what we don't know right now is to what limit should we use it. For example, if you are feeding a client's details into an AI tool, and yet this is a client you owe a duty of confidentiality, will you in essence be breaching this law? So some of these gray areas need to be discussed, and other than amending the regulations, perhaps bar association should also just sit down and draft detailed guidelines for members on when and how they can employ AI to help with their legal work.
Thank you, Patrick. We're certainly going to continue with this conversation, and I'll ask Desmond to give his views and the other panelists as well in a bit. I'd love to just also engage before we do that with our last panelist, Ali Smart. I just want to make sure, Ali, are you online? If so, please just put on your video, and then I can introduce you. Ali will be presenting the position from Nigeria. Ali, are you present? And can we please
I'm fine.
have your video?
I'm fine. Thank you.
Wonderful, wonderful. Thank you, Ali. If I can ask you just put on your video while I'm introducing you, that our audience can see you, that would be wonderful if that is possible. But Ali Smart is a legal practitioner and policy researcher working at the forefront of AI governance and data protection and the digital rights in Africa. And he has served as a technical lead at the Privacy Hub Africa and contributes to digital rights advocacy through the Civic Digital Rights Initiative, and is also active within the data governance and the regulation of emerging technologies. Ali's practical and professional experience and in research and policy engagement on ethical and legal and societal implications of AI, I really think this will provide some unique perspectives within the discussion, and quite appropriate for us to end off the presentations with this. And with your experience, Ali, perhaps I can hand over to you and ask you just to give us your perspectives from Nigeria. Over to you.
Yes, thank you so much. Yes, so I have to start from this point. So currently in Nigeria, the AI landscape is not regulated or driven by legislation, specific legislation. We don't have specific legislations that address the concerns on AI use and technologies generally. So, however, we have existing frameworks on ground, so that are being used or that are extended to AI governance. So, for instance, we have the Nigeria Data Protection Act, we have the Cyber Crime Act, and some other laws on ground to regulate the use of emerging technologies, including AI. However, I would conclude that our AI governance landscape is policy-driven, not statute-led. Yes, so it is policy-driven, it is not statute-led, considering the fact that there are ongoing efforts within government institutions to come up with a specific legislation that would address AI, the use of AI, right, and the users. So because as it is in Nigeria, Nigerians use AI technology, they use AI a lot. They use AI a lot on social media, businesses, even institutions. So everyone is adopting AI. However, there is a specific need to come up with legislation that would specifically address AI use in Nigeria, because people or Nigerians, some Nigerians are abusing it because there's no one to hold responsible. There's issue of risk, consequences. So yes. So another point is that there are many actors involved in the efforts towards regulating AI in Nigeria. We have the civil society are there. We have ecosystem initiatives. We have government institutions. For instance, we have DigiCivic. We have civil society like GGCV, Foundation for Journalism, and some other ones like that. So they are deeply advocating for that there should be a specific legislation that will address the use of AI in Nigeria, because people are getting to abuse it day in, day out. Then another point is that some few years ago, the government of the day came up with a national digital economy policy that seeks to serve as a foundation for emerging technology, including the use of AI. So yes, so we also have the Nigeria Data Protection Commission. So in terms of institutional approach, we have the Nigerian Data Protection Commission, we have the National Center for AI and Robotics. Then we also have the Nigeria Institute for Technology, Nigeria Agency for Technology Development, NITA. So all these institutions are there to ensure that even though we don't have a specific AI legislation in Nigeria, the existing framework could be used to address AI concerns. So yes, and in terms of the legal profession, so we have the rule of professional conduct that regulates the conduct of lawyers in Nigeria. Yes, however, the rule that guide lawyers are not futuristic in nature. Let me put it that way, in the sense that it has no form of tech outlook. So yes, it has no form of tech outlook. So lawyers are, however, enjoying to, deal with their client. There are some responsibilities that are imposed on you as a lawyer when dealing with your client. You have the duty of accuracy, duty of data protection. So you have to protect the personal information of your client. You also need to adapt. You also need to familiarize yourself with technologies that your clients interact with. It's quite important. Also, there is emergence. There is emergence of new advisory roles which involve data governance, data protection, information privacy, cyber security. So as a lawyer, you need to be well informed, you need to upskill in order to ensure that you have detailed knowledge about these new technologies. Yes. Another point is that as a lawyer, you need to have basic understanding of technologies. You have to be tech aware, especially if you know how to prompt. A lawyer should know how to prompt, right? You can use AI to enhance your thinking, to enhance your drafting skills. However, you have to be very careful, considering the fact that your court processes, if you rely on AI, it could bring cases that are fictitious, so which could be dangerous to the outcome of the matters in court. So yes, so there are many responsibilities lawyers hold their clients. So duty of accuracy, you have to be accurate with your information, the information you are getting from your clients. You have to ensure that they are well protected. The duty of confidentiality, you have to be confidential. So yes, so all these are necessary towards ensuring a quality delivery of your services. Yes. So another important point is that our bar associations in Africa, we have that duty to ensure that we adapt or we modify the system to embrace new technologies in the scope of our operation. Some courts in Nigeria are still largely traditional, especially inferior courts. They are still largely traditional. Everything is still traditional, even though there are ongoing efforts at the Superior Court of Records to embrace technology. For instance, there is virtual hearing in Nigeria. You can, some high courts, Court of Appeal, there's virtual hearing in the sense that you don't necessarily have to appear in the physical court before your case is be heard. You can opt for virtual hearing. Yes, So I think that is a right step in the right direction. So the Nigerian Bar Association and partner collaborate with the legislature to ensure that there is a robust legislation that will address the use of AI and other emerging technologies, because there are several ethical considerations like algorithm bias, accountability, risk. So who will be responsible for this? So the legislation should be on ground to cover all this. Thank you.
Thank you so much, Ali. That was very insightful. You were mentioning that there's been quite a bit of a push from Digital Civic and a few other advocacy organizations for regulating AI within the country. I wanted to get your thoughts because there's been different views in the discussion so far. Desmond was saying that adapting existing frameworks is perhaps the way to go, and other colleagues, panelists, were saying maybe not. And because there's this, there is a push from certain organizations within Nigeria for the adoption of AI-specific regulations and legislation. I want to get your thoughts. What do you think is the best approach? Do you think that AI legislation is the way to go, broadly and within the bar associations? Or do you think the existing principles and frameworks is enough in this environment? What do you think is the best way forward for Nigeria? I'd love to have your thoughts on that, Ali.
Yes, my thought is on, yes, my thought is simple. There should be a specific legislation that would address all the concerns in respect of the use of AI. Because the truth is the already existing frameworks are not encompassing, in the sense that they do not specifically address some issues that are unique to AI. So that is why there's a need for a specific legislation that would address that. So AI is widely adopted, just like in other African countries. It's widely adopted in Nigeria by institutions, individuals, businesses, schools. So yes, so we cannot continue to rely on the existing framework or the policies. I mean, for instance, we have the National AI Strategy, which to me is a mere strategy. So it has no force of law, no force of enforceability. So I think enforcement is also another important issue, right? Because if you call something a strategy, so a strategy is just like a guideline. So it's like a guideline that, you know, that should be followed. So the question is, those who refuse, or actors or players who refuse to follow the guideline, what are the consequences that will follow that, right? Yes, so left to me, I would suggest, or I would agree with the fact that we need it now. We need a specific, for instance, I'm going to, there's this particular case, I think it's happened sometimes last year. So there's a popular celebrity in Nigeria. She's a female. So there was a guy, one of our followers on Twitter. So the guy used AI to remove her clothes from her. And she was naked. And the pictures, I mean, the picture was being syndicated around, right? So yeah, so the guy was apprehended by the Nigerian law enforcement agencies. So he was apprehended, and I think he's still in the prison, right? Now, how do we address such issues? Because more of it will come up in the future, right? More of this will come up in the future. How do we specifically address that? Because the existing framework they are just general. I mean, they are tailored to some specific issues like intellectual property laws, cybersecurity laws, yes, cybersecurity, intellectual property, data protection, right? So outside cybersecurity issues, how do we address other issues that emanate from the use of AI? So yes, so I will agree that we should come up with an AI specific, a comprehensive one that will address everything based on our realities, based on our structure, based on the system, right? Because countries differ, right? Nigeria is is a different landscape compared to some other African countries. Our realities are different. Our situation is different. So that is why there's a need to come up with a specific and a comprehensive legislation that will address everything in total.
Yeah. Yeah, wonderful, wonderful. Thank you, Ali. That's certainly a persuasive argument. I think it makes a lot of sense in terms of what you are saying. Every jurisdiction has its own needs and its own requirements, and there's certainly not a one size fits all kind of approach to this. No, thank you very much, Ali. That was wonderful and interesting perspective from the Nigerian perspective. I would like us then to, and first of all, I'd like to thank all our panelists up to this point for your thoughts and perspectives, and also for indulging me with a couple of questions and answers there. I would like to then move on to the next part of our discussion, which incorporates questions and answers from our listeners and viewers. If I could perhaps ask that, and I'll direct it. I'm going to perhaps move on and direct some of these questions to specific panelists, and I'll perhaps throw in a few of my own questions. If you could perhaps put it on your video when directed, that would be wonderful. And then we can take it from there. I do see that there is a question from Bukola. I hope I'm pronouncing your name correctly. And the question here is, will a technology neutral approach not be better? Law becomes outdated quickly, and what happens when new technology emerges? And I think if we can perhaps start with answering, and if I can ask our panelists to perhaps just keep it relatively concise so that we can get through as many questions as we can. But if I could perhaps ask Renee, and sorry for putting you on the spot so quickly, to perhaps take us as the first thoughts to this question. And I start with you, Renee, specifically because of the robust and extensive engagement with regulation and legislation in the Kenyan environment. I'd love to get your thoughts on what Bukola is saying and your views on that before I perhaps move on to some of the other panelists.
Right. Thank you, Prof, for the question, and thank you, Bukola, for the question. So basically asking, will a technology neutral approach not be better? I would say a technology neutral approach is valuable because, like you said, the law tends to catch up to evolving technology very slowly, and it would help, with regards to the development, staying flexible and future-proof. But at the same time, I would say because of the risks that come with technology, the law taking a legal approach to regulating technology and not just a technology neutral approach alone is important. High-risk AI systems automated decision making, synthetic media, just to give an example of what evolving technology can do, or even the impact that it has, require for the law to step in to regulate and to even direct how we go about such situations. So I think it's all about a balance, balance the approach in terms of technology and law, find a way to balance it, and also adding a number of principles that are foundational to the creation of the laws. So things like ethics, fairness, transparency, integrity. I think that would assist us. I hope that gives a sort of answer to your question. Yes.
Thank you, Renee. Yes, Rachel, I see you want to also add. Please go ahead. We welcome your thoughts.
Thank you so much. This will just be very brief to Bukola also on the question. Sometimes it is good to also think about how different values and different principles apply to your jurisdiction, to your area, to your country, and maybe use that in how the legal systems and principles can be created. Because to your question, yes, the law does become outdated, technology is moving quickly, but then you do find elements in different laws, different acts of parliament that already say, for instance, no, do not discriminate a person against their religion. Laws that prohibits, explicit content, maybe targeted on children, cybercrimes, and things like that. So whereas there are systems and provisions that can be very general, they already address the challenges that we are seeing with artificial intelligence now. So is it good to have a revised law from time to time? Yes, it is. But with the laws that are already in place, the implementer, the executor of that law can be innovative and creative enough to make sure that as they're implementing, they are addressing the different challenges of the different groups or members of society with regards to 1, 2, 3. That was just my quick response. Thank you so much, Michelle.
Excellent. Thank you, Rachel. I am going to just manage the questions as we go along. So there has just been a few that's come in on the chat. So Nomalanga is asking, to what extent should we succumb to the geopolitical influences and the race to regulate AI through dedicated legislation? And I'd like to potentially and ask Desmond to perhaps answer this, because I'm interested to see what your perspectives are, especially with your initial view of we don't need to regulate necessarily, but we can adapt existing principles. It seems to me that there are potential risks in running this race. And I'd love to get your views on that, Desmond. And then I'll ask one of our other panelists to also address this.
Right. Thank you very much, Prof. Coming back to me. So first of all, for the greater part, the reason why we want to regulate AI, and I'm moving away from just legal practice to discuss AI in the big picture, is more of the harms. That's the truth. If you break down the AI governance structure, AI ethics, responsible AI, the bottom line is we want to address the risk. Now, from my research, which of course might not be exhaustive, but the greater part of the harms that we are discussing is in 3 parts. Individual and rights-based harms, so privacy issues, bias, discrimination, loss of human agency, if you like, consumer deception, misleading AI outputs. Like, we got one example from Ali trying to paint the picture of deepfakes, in whether in videos or in images. Sometimes child's rights, and then the harmful decisions that would impact any aspect of our lives, like health, education, and the likes. So individual rights-based harms exist in AI. Then there is a concern about societal, democratic, and security harms, which goes with the disinformation, sometimes election interference, sometimes manipulation, deception, AI, dark patterns, so cybersecurity misuse and stuff. I mean, I can't be exhaustive about them. And then you can look at the economic and governance systemic harms that comes with AI deployment, AI use. So issues about accountability gaps. Where's the moral agency? The lack of transparency, explainability, or AIX, auditability, and IP issues and the rest. These three concerns, they exist in every mature legal system. You already have existing laws that are addressing these things. So the position that we take is that if you want to address AI arms, which, like I said, is largely the bottom line of all these conversation. When we sued OpenAI before the FTC in the United States, the concern was about ChatGPT not making room, right, for the various, if you like, guardrails that would protect children and young adults from using the platform. So fast forward, ChatGPT through OpenAI has so many of those controls now. The concern was about the impact that is going to create on these people. And we went back to an existing regulator, the Federal Trade Commission, who was able to deal with some of these issues at the regulatory level in the hearing. And that also helped OpenAI in addressing some of the work that they did, including the research that was done by some of us. So the point that I'm trying to drive home is that you need to look at the existing structure. I agree with Ali, environments differ. But if enforcement is the reason, then a new law, omnibus AI law, I'm telling you, would not achieve it, because enforcement has nothing to do with the law itself. Enforcement has everything to do with logistical effect, the management of resources, budget, training, capacity building, and the implementation of these various modules, as the case may be. So if it's really about the existing structure not being able to be forceful enough to implement enforcement on the existing regulatory regimes that we have, a new law is not going to change that. Concerns with geopolitics. I'm a fan of geopolitics. In fact, I have studied most of these technology laws from the point of view of democracy, tech colonialism, and the rest. Now, to the extent that you are leveraging on these external platforms, then you would want to be tempted to module how they regulate it. But I'll go back to my various speakers. Africa has different, problems and different outlook. Global village, I agree. AI is universal, I agree. But don't we want AI that speaks our language? I have used platforms that were reproducing legal advice, and it was absolute, forgive my language, balderdash. It really has nothing to do with Ghanaian law. But this system was thinking that because the scenarios and the facts seem to be similar, they could reference different provisions in different jurisdictions on which these AIs have been trained to provide me with answers. That is where the competency issue comes in. That's not really a technology issue. That's a competency issue. And if you're dealing with it from a legal regime point of view of legal regulations in terms of the profession itself, then you want to address who is using these platforms, which is the lawyer, which is the law student, which is a lawyer in training or counsel in training. That is where the outlook should be. Can we look at the existing structure? Is it convincing enough from an enforcement point of view? If that is the test, a new law is not going to change it. A new law is not going to make it any different. An omnibus law is not going to make it any different. EU is your go-to purely because they have the strongest regime of enforcement. Even the US has that as a force to reckon with. And I think I'll just wrap up here. Thank you.
Thank you, Desmond. I think that's it's an interesting view because it does give us a different perspective. And thank you so much for that. I am going to, and I would love to have some other views on that as well, but I think there's quite a few questions. So let's see how far we can get. Natsaluba is asking, what is Africa's agenda as derived from from Africa we want regarding digital technologies? In singular approaches by only legal practitioners assisting that agenda, then a comprehensive roundtable to realize privacy by design developer posture, then consumerism approach. I'm going to open this question up to the panel and perhaps ask if there are any views. But I'd love to get Patrick's view to start with, in terms of how do these digital technologies, where's the African agenda deriving from? And perhaps, Patrick, if I could ask just your initial views on that before we move on to the rest of the questions. Patrick, the floor is yours. Thank you.
Thank you, Michelle. Yes, regarding the question, I will tend to think, the approach should not only be by legal practitioners, but, the legal practitioners should lead this conversation in, ensuring that, there is a singular approach to, tackling or, to realizing, a uniform AI guideline. I'll give an example of the data protection, the Malabo Convention. The African Union, in their wisdom, decided to develop a policy guideline that has been of help to many of these countries that have adopted data protection laws. So yeah, I'd suggest that the African Union could engage practitioners and stakeholders in coming out with a framework that will guide the use of AI in African Union member states. This, of course, will help us to set this framework, different country frameworks, and ensure there is there is that uniformity in the use of AI in the continent here.
Thank you, Patrick. That's a wonderful insight. I love the contribution to that. I don't think it was the easiest perspective question to answer, because there's so many moving parts to this, but wonderful insights there. I see there is a question directed to you, Renee, specifically, and then I'll move on to the next question. But Renee, Luke is asking you, what is your take on the recent investigation launched by the Kenyan Office of the Data Protector Commissioner into Ray-Ban's Meta smart glasses, following complaints on privacy violations and the misuse or mishandling of personal data of the citizens, and the fact that it is alleged that this personal data is then viewed or processed in Nairobi to train Meta's AI systems. Renee, can I perhaps ask your views on that for Luke before we tackle the rest of the questions?
Yeah, sure. Thank you, Luke, for the question. I think that it's an important thing that the ODPC is doing. One thing, when you come to Kenya, you'll notice about the ODPC is they're very proactive when it comes to compliance in Kenya. They enforce compliance both in the private and public sector. So I think that it's an important thing that they're doing, especially as a regulator, because this is a new technology that has entered the market, and it's not a local technology, it's an international technology. And the thing about wearable devices, they record audio, video in public spaces, which brings about issues about consent notices. Are the people being recorded aware that they're being recorded? Are they aware that their data is being collected and will be used in a manner that they are not perhaps comfortable with? Even we saw the situation that happened within Kenya, those ladies being recorded without their consent. So it is an important thing that the ODPC is doing with regards to looking into that issue and what happened. I also think another thing that you've mentioned, the issue of the data that is being collected using this Meta's, the Ray-Bans, how is it being used? That goes to issues of cross-border data flows, the safeguards when data is transferred from one region to another. So these questions come up with regards to data protection. and the protection of the data of those who are recorded. So I think what the OTPC is doing, what they're doing is a really good thing. I look forward to seeing how that investigation will turn out. Yeah, but I think it also signals both to local and international actors that as Kenya, we do take issues about privacy very seriously. And that if you are coming within the region, within the country, then you have to abide by our laws. And I think that's a very good message, even for us as Africa to send, that when you come to Africa, you go to Rome, you do what the Romans do. So yes, yeah, in short, that will be my answer. Thank you.
Thank you, Renee. Wonderful. I'd like to direct the next question to Ali because I think this aligns very much to what you were speaking. Sharon is asking or making the following statement, and I'd love to get your views on this. Whilst we all have some form of policy or strategic approach to AI in Africa, there are at this stage no specific sanctions for non-compliance where AI is concerned, whether through the existing legislation or competency. Unless we take a more granular approach to risk imposed by AI and the management thereof, innovation remains unregulated. This granularity should take the form of sectorial regulations which are measurable, which then can be adapted to changing technologies. Innovation without regulation remains unharnessed and poses the greater risk. The benefits of AI are immense, but this risk posed by AI will be equally damaging. As it stands, the open source platforms have no accountability. And I believe Sharon is also perhaps commenting on what Desmond was saying. So Ali, I'd love to get your thoughts on this and perhaps a different view as to these regulations within Africa. If I could perhaps ask your views in response to the statement, that would be wonderful. Thank you.
Okay, yes. As it stands, open source platform have no accountability in the sense that most of the AI systems that we have, they are open sourced. So anyone from anywhere can have access to them, can use it like ChatGPT and the others. So yes, so this still goes to the issue of compliance, right? So to enforce or to ensure compliance, there must be specific legislation on ground to address that. So policies are not enough, AI strategies are not enough, AI guidelines are not enough, existing legal frameworks are not enough to address all this, because since it is open source, it means it is open to the members of the public to use. So who is going to hold anyone accountable if AI is used to commit harms? So this is a question of accountability. There's the risk involved in the use of AI. So how do we address that? How do we address a situation where a child, a minor that is not up to 18-year-old is deploying AI, to commit harms? So how do we address some of these issues? They are not, you cannot find data protection laws, cybersecurity, we will never see any provision that specifically address some of these questions. Accountability, compliance, risk, bias. So yes, so how do we address some of these issues with the existing legal framework, if not a comprehensive legislation that addresses all the concerns, the implications, and the scope of AI as a technology? Then another point is that in Africa, laws are not our problems. making laws are not our problem in Africa. The problem is enforcement. So how do we enforce some of the existing legal framework, right? So if we get to make specific legislation for AI use, how do we enforce them? How do we enforce them? How do we ensure there is accountability, there is transparency on the part of the users? So how do we take businesses that use AI, how do we take them responsible? So these are some of the implications that need to be addressed. So left to me, in Africa, AI models are generally unregulated. They are generally unregulated, and AI has come to stay with us, and we need to do something to conform with the realities on ground.
Ali, I think that's a wonderful point. You mentioning that the problem is enforcement and something needs to be done. Yeah.
Yes,
yeah,
something
wonderful.
needs to be done.
Mm. No, wonderful insights there. Thank you, Ali. I want to try and get through some of the last questions so that we can address all our listeners and viewers' questions. But I'd love to engage with the panelists as well afterwards for further engagement. But Barima is asking, is data protection laws in most African countries currently strong enough to support the safe AI deployment? Rachel, I'd love to get your views on this specifically. A lot of the discussions up until this point have been there are existing frameworks and there's been a focus on the data protection side of it. Are
Yes.
those things, are those sufficient? Yes, Ali, I'm just quickly asking Rachel, and then I'll get your views on this as well. Thank you. So Rachel, what are your views on the data protection laws at this stage?
Thank you so much. And just very briefly to respond to Barry Miles' question is the data protection laws that we have in the African context. I'm very glad to have worked with a few African countries and have really looked into their laws. They do make provisions on how data can be correctly used and stored and things like that. And which is why, even to Berima's question, it is important to remind yourselves once again, what does AI do? What does AI do with your data, with your information? Okay, AI records, it analyzes, it processes, may share with a third party, and this and that. But AI is using the information provided to it. So you want to protect this information, you want to protect this data from unethical usage, from theft, manipulation, and things like that. So you do see, just speaking generally, data protection laws do have several provisions about how your data can be protected. Now, does it specifically say how your data is protected within AI tools or AI systems? The data protection laws tend to be very general. They're just talking about your data in general. Okay, so you have the rights to access, you have the rights to request your information not to be processed anymore, you have the rights to have your data deleted, right from automatic decision making, so many things, which you see are elements that AI tools and AI systems are already using. And now what I think with this is also, it would be better, and it is better, if there is a specific AI instrument now that can target all the other technicalities, all the other liability issues, and I don't know, even complaint settlement, how decisions can be enforced with regards to AI itself. But to bear in mind, it's also very important to think and look at your jurisdiction, your area, maybe even the work, the sector that you do. do you want, is it better for us to have just a strategy, just a policy, or do we want to have more binding instruments? Even with AI, is it enough to just have a strategy and say, okay, this is our strategy, or okay, this is our framework, or this is our guideline, or do we want more binding instruments? Will that make AI deployments, will that make AI developers, users, will that protect them more? Will that hold the right people responsible and things like that? But data protection laws do have segments where they talk about how your data can be used, including how AI uses your data. To moderator Professor Michelle, if you may allow me to quickly answer his second question, I may have to drop off real quickly, if that's okay.
So please go ahead,
It's
Rachel.
less than a minute, I promise.
Okay.
Berima is also asking if African customary laws and indigenous knowledge systems should play a role with AI governance. And this is what I believe Patrick was saying earlier. We're talking here about the legal profession, maybe about the legal sector. The legal sector cannot work on AI governance by itself. In fact, it should be very close, working daily, talking daily to the developers, to the technicians, to researchers, and to all these other different groups and different stakeholders, if we are to reach a place where AI is being deployed responsibly, there's a general understanding of it, but even to make sure that in our African context, with all our different cultures, our different languages, the music we have, the songs we have, the arts, and so many things, local indigenous knowledge is best, and it's good that it be deployed in AI governance. Because imagine how more relatable AI will be if you hear AI speaking in Shona, in Zulu, and Swahili all the time, or maybe at a larger scale, as opposed to seeing or hearing AI tools in English. Imagine an AI singing you a song that you grew up with in school as a child in your local language, and AI producing all these many things that are central to your culture. So the people working in the indigenous knowledge systems should also have a very big part in AI governance. Thank you so much. Thank you so much, Professor.
Thank you, Rachel. Thank you. Wonderful insights. Renee, I'm going to give you a chance to also just respond, but then I think we need to wrap up, and I'll ask one final question to all panelists. But Renee, if you want to perhaps add on to that, you had your hand up but if we can keep it concise, because we are running out of time. Thank you very much.
Yes, thank you, Prof, and thank you, Rachel, for that answer. I actually just have very little to add with regards to the first question about is data protection enough. We also have to remember that technology keeps evolving, AI keeps evolving. Right now, within the AI space, what people are talking about, particularly in the global north, is the next level of AI is what we call autonomous agents. And basically, autonomous agents are systems, AI systems that can perceive the environment, make decisions, take actions with very limited human involvement or human prompting. So if you take into account and we see where technology is going, we can't only have data protection regulating and being in charge of AI deployment, especially in Africa, because in Africa, what usually happens is development happens in the global north, and then we receive after those systems after they've already been developed. They provide for us those systems, and then we build using those systems created in a very different context from our context. So I just wanted to add that we have to be on top of AI deployment, and not just with data protection, but in various ways. And like Rachel was saying, with various actors within the ecosystem, so that we can develop a good regulatory system for Africa. Yes, thank you.
Thank you, Renee. That's wonderful. I see we are even being told that the recording, we're quite over time, but it was such a robust discussion. Perhaps I can ask our panelists, and I'll go through the panelists, just as a conclusion, if you could literally in one sentence, maximum 2 sentences, so 10, 15 seconds, if you could give only one concise piece of advice to a jurisdiction, let's say even South Africa, because everyone would have seen South Africa has issued its AI policy document, which was withdrawn because of the AI, the hallucinations in it. But there's obviously some regulation that we need to look at. If you can give one concise piece of advice as to how we need to go about regulating and engaging with AI, what would that be? And if I can maybe ask Ali for your one or two sentences on that, and I'm going to go through our list. If we can just keep it very concise, I would appreciate that. Thank you. Ali, your piece of advice for South Africa and any other African jurisdiction, what is the top one that you would provide? You are on mute, Ali. If you can perhaps just unmute yourself. Thank you.
Yes, can you hear me?
Yes, please go ahead.
All right. So my piece of advice is simple. So Africa should make the coordinated efforts to ensure that our our regulatory environment is harmonious, right? I mean, we should be united in terms of regulations, in terms of policies, and we should ensure that we should not allow geopolitics to affect our environment, considering the fact that if you look at global AI governance, the policy tables are dominated by countries in the global north. So Africa should be united in respect of that, so that we can have a voice, we can have a place on the table. We should be a reckoning force. We should be a reckoning force, on the global policy tables in respect of AI. Of course, I'm pretty aware that our realities as a society are different. However,
Yes.
when it comes to global affairs like AI, so we should be united, we should stand, and we should ensure that we take our place on the global policy environment. We should be a stakeholder in the room. We should not be associates. We should not be associates. We should be stakeholders in the room. So that is my advice.
Excellent. Excellent. Thank you, Ali. I'm going to quickly go over to Rachel because I know you need to leave. If you can perhaps just give us your words of wisdom just very quickly.
Yes, thank you so much. Ladies and gentlemen, please understand and learn AI. Take a course if you have to, take a program, join a fellowship. Understand AI to the point that you can explain it to a 10-year-old child and they would understand you. Understand and learn AI to the point that you can explain it in your mother tongue, even in your tribal language, if need be, and the person listening to you can understand. Because once you're able to explain something complex and complicated in a simple way, then you've really understood it. Then as a lawyer, when a client comes to you who has maybe a very basic understanding of AI, you are able to break down and understand what advice or what solution to give them. That's why if a policymaker wants to put you in a roundtable of experts for a certain document to be created, you are able to break down those different elements. You're able to provide solutions. So there is a lot of excitement and hype going around about AI. I can promise you that. You see, everybody's an AI expert. Everybody's an AI expert, yes. But really understand AI. Please, really, really understand it for your work, for your systems, your sector, and all of that. Thank you so much.
Thank you very much, Rachel. Patrick, your views, your concise words of wisdom for us, if you perhaps just want to add that. All right. Otherwise, Desmond, your views? And then Renee, your views, and then we'll close off.
Right. Very quick, very, very quick and brief. To start with, the unavailability of a standalone AI Act does not necessarily mean there is a legal vacuum. I would advise states, countries, whoever the authorities are, let's not haste into a regulatory fog. If there is anything we should be doing now is focus on the competency ladder and of course ensure that as a national direction, we appreciate a risk-aligned approach to doing this. Thank you, Prof.
Thank you very much, Desmond. Renee, your thoughts?
Yes, thank you, Prof. I'll try to keep it brief. The first thing I would say is for all African countries, we first need to understand our ecosystem, what is happening within our context, and that will inform how we respond, how we approach regulation of AI within our context so that we are not putting a burden on the local development or deployment of AI, but at the same time regulating it so that there's a balance between the two. I would also say, particularly for Kenya, if I can speak for Kenya, sector development of sector regulatory development. So I would say Kenya would be best placed to develop regulation sector by sector. I genuinely think the 2026 AI bill was rushed. And it doesn't take into account what's happening in Kenya. And I can say that can also apply in various African countries. The next thing I would say, as I conclude, is I think as Africa, we need to keep pushing to be on the globe, on the front in terms of we need to be in the global space when it comes to these dialogues of AI governance. We really need to push and make sure that our voices are heard. And that even as they develop frameworks internationally that will apply here, we are speaking and saying what will work for us in those spaces. Thank you.
Wonderful. Wonderful, Renee. So just in summary, what I'm hearing is a consolidation of approach, education of AI, a competency ladder, risk alignment approach, and understanding our ecosystem. And those are the thoughts and points of wisdom from our panel. I would like to thank the panel for their insights and their wisdom and certainly the experience that they've shared with us. I know, Nomalanga, we did go over time. I do apologize for that, but I do think that there have been some excellent contributions and robust discussion, different views, and this is what we need to drive the discussion forward. So I thank you for your patience on this as well, and our panelists for a wonderful contribution, and also for our audience. Thank you so much. I hand it over to you, Nomalanga. Thank you.
Thank you so much, Prof, for handling that with so much grace and elegance. And thank you to our esteemed panel as well. I know some have had to leave to their other meetings, but we do appreciate all your insights, and we will be following your work from here on out to find out more of your contributions, more of the developments coming from your countries. And I'll personally say, from the perspective of the African Cyber Law Conference, you will be one of our primary touch points for the countries that you represented today. So thank you very much. And if I'd like to ask the audience if we could give them a round of applause. Thank you, Prof. Michelle, again for moderating the session. We will be publishing the contents of this webinar, obviously subject to the permission of our speakers. I don't want to violate anyone's image rights, but thank you so much. And for those of you joining us next week, Wednesday, in the data governance discussion around South Africa's future AI policy, we will be having industry perspectives. The information regulator of South Africa will also be represented, as well as Professor Papadopoulos, who's a cyber law leader in South Africa, will be there to take us through what the AI policy in South Africa should look like when it eventually comes back to the table, because we've been in such a difficult position in South Africa. But we will not be stifled.